Hello, everyone. Welcome back to our channel, Immigration YT TV. We hope you're doing great. In this video, we're going to talk about USCIS tightens CSPA age calculation for green card applicants. USCIS is revising how it determines a child's age under the Child Status Protection Act for green card applicants, effective August 15, 2025. The agency will now rely solely on the Final Actions Dates chart from the Visa Bulletin, a change that could limit eligibility for age-freezing protections and increase the chances of children aging out before approval. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. A significant policy shift from U.S. Citizenship and Immigration Services will soon reshape how children's ages are calculated under the Child Status Protection Act. This law was originally designed to shield young immigrants from aging out, losing their eligibility for certain immigration benefits when they turn 21 during long green card waits. Starting August 15, 2025, USCIS will only use the Final Actions Dates chart from the State Department's monthly Visa Bulletin, a change that could limit protections for many young applicants, particularly those caught in long immigration backlogs. From generous timelines to stricter cutoffs. Previous policy, February 2023 to August 2025. Until now, if USCIS permitted applicants to use the Dates for Filing chart to submit their adjustment of status applications, that earlier date also served as the benchmark for calculating CSPA age. This often worked in families' favor, effectively freezing the child's age well before the green card was issued, ensuring they retained child status and avoided falling into a slower, less favorable visa category. Revised policy, effective August 15, 2025. Going forward, USCIS will only use the Final Actions Dates chart to determine eligibility for CSPA age protection for applicants filing from within the U.S. This change aligns domestic processing rules with those already applied to overseas consular processing cases. Applications already pending with USCIS before August 15, 2025, will still be reviewed under the older, more lenient rules. The agency has also stated that it will consider extraordinary circumstances for applicants unable to file during the prior policy period. Reasoning behind the shift. According to USCIS, the policy update aims to eliminate inconsistencies between consular processing and adjustment of status cases. By applying a single standard, the agency argues that outcomes will be more uniform and predictable. The human toll, how families may be affected. For many immigrant families, the change could mean the difference between staying together and being separated for years or even decades. If a child turns 21 before securing a green card, they age out of the immediate family category and shift to an adult child visa classification with significantly longer waits. This change is especially troubling for families from countries with large visa backlogs, such as India, Mexico, and the Philippines. These delays can have ripple effects: emotional stress over uncertain immigration outcomes, interrupted education and career plans for the young adult, increased financial strain from having to explore alternative visas, such as student or work permits, to remain in the U.S. Families will now need to approach the process with greater urgency, carefully monitoring Visa Bulletin movements and consider alternative pathways to avoid aging out. Consequences for U.S. businesses and employers. Employers who sponsor skilled workers for permanent residency also have a stake in this change. Dependent children of employees on long-term work visas may lose eligibility for green card benefits under the stricter CSPA age calculation. This shift could make the U.S. a less attractive destination for global talent with families, lead to retention challenges when workers face family separation risks, push companies to invest in faster processing strategies, including premium processing, increase the need for legal support to navigate more complex family immigration cases. When family stability is threatened, employee morale and productivity can suffer, and top candidates may choose countries with more predictable, family-friendly immigration systems. Steps families can take now. Families facing the possibility of aging out should act before the August 15, 2025 implementation date, if possible. This may include filing adjustment of status applications now, if eligible under current rules, seeking guidance from an immigration attorney to understand exact filing windows, exploring alternative visa options to keep children lawfully in the U.S. while awaiting green cards. Preparing the workplace for the change. Human resources teams and corporate immigration managers should proactively address the new rule by reviewing all pending green card cases involving dependent children, informing affected employees about the upcoming change, developing retention strategies that account for potential family separation, and coordinating closely with Immigration Counsel to evaluate expedited filing opportunities. Looking ahead, the USCIS policy change on CSPA age calculation is more than an administrative adjustment. It's a decision that could shape the futures of thousands of young immigrants and influence how the U.S. competes for global talent. The new rule is expected to impact thousands of immigrant families, especially from countries with long visa backlogs, and may also affect employers sponsoring skilled workers. To avoid disruptions, families and businesses must act quickly, closely monitor visa timelines, and seek legal advice to adapt to the stricter requirements.